Good evening, students. We, the mentors for the today's session on paper 2, corporate and other laws on the live virtual classes. Welcomes to you all. We, the mentors here, my colleague Shraddha and myself, Nisha. Welcomes to you all. Dear friends, this is being the first session of the live virtual class. That means the technical session I'm talking about. And this is the technical session on chapter 1, that is the preliminary. So as already earlier we have discussed about the syllabus, because before you just start with any of the topic, you are being required to know what is the syllabus. Okay, if you see the corporate and other laws, it specifies that there are broadly two parts. Okay, the part first, which deals with the corporate law covering the Companies Act and the LLP, Limited Liability Partnership Act, which is forming of 70 marks, and the other law portion, which covers the three acts. Okay, the first act, the FEMA, second, you will be finding GC Act, and third, the interpretation of statute, which is forming 30 marks of your syllabus. So this is the thing, and you will be finding that in the corporate law under the Companies Act portion, you are being specified the limited sections. That means the entire Companies Act is not forming the part of your syllabus. It means it is covering section up till section 1, from section 1 to 148, and from section 390 or 379 to 393. Yes.
So basically, we are covering sections 1 to 148, starting from the section 1, which is your commencement of the Companies Act 2013, and covering till audit and auditors till section 148. Since we are trying to cover the major types of companies, like whether incorporated outside India or in India is obviously there, so we are covering outside India also. That's why we are covering section 379 to 393, which is chapter 22 of the Companies Act. If we see the act as it is, so it is chapter 22 of the Companies Act 2013. So those provisions also we are covering majorly the both the type of company incorporated in India and outside India. So, and other form of organization that we are covering is the limited liability partnership, which is covered as per the provisions of the Limited Liability Partnership Act 2008.
Yes. And if you see the laws basically being covered over here at the intermediate level, the Companies Act or the LLP or the FEMA, basically these laws are dynamic in nature. That means they keep on changing as per that there's a requirement of change in the corporate scenario. So what happens in such a case? You need to keep yourself updated. That means you need to keep yourself attuned with the recent developments which are being which are being brought before the public through the way of the notifications or the circulars, which are made by the concerned department or the authorities.
So, ma'am, like we are saying that this is a dynamic, these acts are dynamic in nature. So, if you see, we are covering four acts basically: the Companies Act 2013, the LLP, then the Journal Clauses Act, and the FEMA.
Yes.
But if you see, three acts are dynamic in nature. But the fourth, which is the Journal Clauses Act 1897, that is not that dynamic, because most of the laws as are there in this act have been decided like way back, and not major amendments have come. But if you see Companies Act or the LLP or your Foreign Exchange Management Act 1999, these are dynamic because the kind of things that they are dealing with. If you see the Companies Act is dealing with the overall working, management, procedural things, and also the penalty that may be there if you are not following the law. So, as and when the scenario of the economy changes, at that time what happens is you have to change the act or the legislation accordingly. Then if you see the LLP Act 2008, since we will be discussing that also when the time comes, but we are just explaining that why these are dynamic in nature, because as far as the LLP Act is concerned, it's a kind of amalgamation between the partnership kind of business and the company form of a business. That's why it's like Limited Liability Partnership Act.
Actually, the thing is that for ease of doing a business, so
Yes.
this LLP form of business was brought into the picture. And to regulate that nature of the business, the LLP Act was brought into the enforcement. And of course, the Act as well as the regulations or the rules to how to implement what the Act has been enacted. So we have to read the LLP Act along with the relevant rules
Rules.
that we have covered in the study
So
material.
this will also change a lot because as and when the economy changes, the dynamic nature is there of the economy, so the dynamic nature of the law also. Similarly, if you see the Foreign Exchange Management Act, it will also change very regularly. Reason being that it is governed by the global scenario, and we have to change it as per our economy and the global scenario. So this will also change a lot. That's why you will see the major amendments in all the acts that you are studying only will come in these three acts.
Yes. And due to the change, for the fast change in the market trends, and that is where there is leading to change in the environmental scenario. And due to the technology advancement very fastly, all the laws are being changing due to get equipped with the digitization. And that is why fulfilling the dream of our Honorable Prime Minister of India.
Shri Narendra
Yes,
Modi
Shri
ji.
Narendra Modi ji, Make in India, the digital, digital Make in India. So that is why this is the dream and that is being fulfilled through the way
So
of these kind of
whenever
dynamic changes being
So
incorporated.
whenever you see an amendment, don't be afraid. Just think it as a positive step towards an enhancement in the legislation that you are reading. So this was a brief background on the part that since many students are right now, we are receiving some queries that why the law is changing, why we have to read so many amendments. So you have to read so many amendments, though not much amendments are coming. So amendments will come and take it in a sense that they are for the betterment of the legislations that you are reading.
In
Similarly,
fact, it is for the professional development, something
yes.
to get in tune with the changing of the scenario. So that is the need of the art to get updated with the changing environment. Okay, and further, you must be seeing that what we are expecting at the intermediate level, that is also very important because we have prescribed in the syllabus the objective. That is very much important to understand, dear students, because objective means with what intent you have to understand the subject, up to what level, how much in depth you need to go into the paper. So this is very much required. So you read the objective whenever it is given in any of the subject along with the syllabus. So objective, if you see the learning objective given in the paper, is to develop an understanding of the legal provisions, to acquire the ability to analyze the laws in the practical scenario. This is the objective that we have mentioned for the part first of the syllabus. That is the corporate law, which is covering of the Companies Act as well as the LLP Act. So you understood that the objective is to, you have to acquire the knowledge with what intent, that you tend to develop an ability that you are able to apply the law in the practical scenario. That means there will be application testing. It will not be just focusing on the simple reading of the act or simple, comprehensive understanding of the knowledge of the subject. But yes, in fact, you need also to develop that capability, or you need to develop yourself or to take yourself to that level that you're able to apply the law. So that is the thing, and able to analyze the situation in line with the requirement of the law. This is the objective. Okay, and when you go for the objective of the other law portions, so you'll be finding that you are requiring to have a general understanding of the General Clauses Act as well as the interpretation of statutes. And with respect to the FEMA Act, you need to have the the basic understanding, you can say, of the FEMA Act. Okay, so this is the objective. So when you are reading a subject, accordingly pay the focus, because that is the, that the level that is being expected for understanding the subject. So in order that you can learn accordingly, you can understand subject accordingly, and you can apply accordingly as per the requirement of the subject.
So that was we in the last class also we have told you many things with respect to the same. This was a brief overview, like why you have to read the amendments. And then in this class, this is like since this is your first technical class, so we will be taking things a bit slow so that you understand things in a better manner. So going further, ma'am,
So let's start with the topic.
yes. So
Yeah.
there is one thing that I would like. We are again and again saying Companies Act 2013 or the LLP Act 2008 or the General Clauses Act 1897. It is very important for all of you to write the full name of the act. Whenever you are writing the name of the act, always write the Companies Act 2013, like the companies. Okay, we have just a moment. Writing.
Students,
Okay,
one
so
should have, I would
they
like to reply to the Miss Rinky.
okay.
Miss Rinky, hi, and it's great to see you over on this platform. Miss Rinky, it's nice to see that you are requesting to show with the content. We will come up with the content here. But only the thing is that unless and until you are not aware of the background, why the law was needed, you will not be able to understand the concept very well. You should be knowing what is the intent of the law, legislators to enact this legislation. So that is why we are just creating and knowing it the background, and then we will start up with the main portion of the this particular topic. Okay, and why we are just saying every time repeating the full name as Shraddha told, this is being required. When you're writing the answers, you are expected to have the complete name of the act. So it matters. Whatever you have read, you should know exactly what the name of the act is. Okay, so this is the thing. So let's proceed with further.
Okay, I,
Chalo, dear students, I could be seeing that you all are enjoying class very much, but
I'm sorry,
scribbling
but
on the
no, this
screen,
scribbling is done by me.
how it's possible for you?
No. I'm just trying to erase. Okay, let me just have another page, I think.
Anyways, till the time you do this one, I'll just apprise with the students about the Companies Act. Okay, what do you understand by the term companies? Let's take in that way. Before we start with the Companies Act, you should understand what is the meaning of company. Can any one of you students can let me know how you will define the term company? You must have heard lot about the word company. Yes, this is the X company. Yes, this is the Reliance company. Yeah, this is the Tata Sons Limited company. So you might have heard Infosys Private Limited. So you might have heard many things about the companies, but I just want to know, what do you understand by the term company? So dear students, I just want to know from your side, what do you understand by this term? Yes, student, just waiting for your reply. Anyone? Yes, anyone of you students?
So they are replying to me
Mhm.
on the.
Yes, what is the meaning of the companies? Yes, there are many students who are raising their hands.
I'm just writing what I was telling them. Excuse my writing.
Okay, the legal.
So this is the way we have to write the name of the act. Queries. So you will write the whole name of the act. That is the Companies Act, 2013. Then the Journal Clauses Act, 1897. So this is the way to write the whole name of the act. हाँ, तो लिखना बंद करना. So we are getting answers from the students saying a company is an entity which is made by law. Quite correct.
Okay.
Separate legal entity in the eyes of law. A person without fundamental rights like citizen. It is a person in the eye of law. So that means your concept in that sense is very clear that it has to be recognized in the eyes of law. A company is a group of persons join together to do some work with a motive to make profits. Very correct. So
this is the ordinary meaning, okay? And now we are going to go in line with the Companies Act.
So, one of the students have wrote that it can own assets in its own name, incur liability. So these are the kind of, what should I say, features. Okay. So you are giving me the features. If you are asking for a definition or the meaning, so you need to give a meaning. Iska matlab kya hai? What do you understand by that term? What you are saying is a kind of features. So understand this point very clearly. Your answer is not wrong, but when the question will come in exam that what is the meaning of company, that will be different, and what are the features of a company, that will be different.
Yes.
So almost all the students have given the correct answer. Himani, Chaitra, Arzra, Shraddha, Aryan, Sakti, Anantra, Mustafa, Vaishnavi, Rinki, Jaya. Almost all students have given the correct
Yes,
answer.
even Dinanath Gupta has also given the right answer. The company registered under the Companies Act and they are bound to follow the rules and the regulations. So very good. So this is the whatever the term you have explained, the word company is absolutely right with in the general and ordinary sense. Now let's go as per the extra. Then let's start the today's topic.
So should I share the PPT?
Yeah. So if you see in this topic, basically, we are going to cover what, if you see, I hope you already must have seen this chapter in your study material. So in this chapter, we'll be seeing that what we all are covering over there. So we are covering, we are covering the section 1, which deals with the title, extent, commencement, and applicability of the act. Okay, and yes, here is our PPTs. And then we shall be discussing about the various relevant definitions that are being expressed under this Companies Act 2013. So you must be seeing that this is the overview of the chapter that we have shared. Are our PPTs visible to you, dear students? You have shared it?
Yes, I have.
Yes, student, please give the reply on the chat box. Is the notes visible to you?
Yes,
thank
they are.
you.
Thank you.
So, okay, so we will be discussing over here, as already I said, this the coverage of the topic, what all is there. Plus, we will be discussing about here the extent, the commencement date. Plus, you will be seeing the applicability on all what the Companies Act is being applied, and also the relevant definitions, as already told you. But before this, there's a one term used over here is the preamble. Preamble. Have you ever seen the Bare Act, dear students? If you see the Bare Act, just before the title, the name of the act, you will be finding a few lines stating about the preamble of that. Preambles means something introductory statement about the statute. Okay, so it not only specifies with what intent this act has been framed or enacted, it also specifies the scope, objects, and the purpose of the statute. So this preamble has its own relevance. Why does it need a preamble? Why the preamble is given in every act? The preamble is basically relevant where there is any inconsistency or there is no clarity or there is a kind of their interpretation in the you can say more than one meaning can be drawn on a particular phrase or the sentence or of the statute. So in that case the preambles helps you to draw the you can say the reasonable constructions or the interpretation of the statute.
Preamble is basically a kind of preface to the act. So
Yes.
before any act is started, we give a preamble. If you see, when we are reading any novel also, there is a preface which tells about, okay, so this is set up in like this, or that is the background of the act or of the novel. So it gives you a brief hint of what the act is dealing with.
Yes.
So it's a sort of preface, and it is, though it is not exactly a part of the act. However, many a times when we have to understand that what was the reason behind the enactment of the act, we can go back to the preamble of the act and we can refer it for interpretations.
Yes, so it is basically telling about the intent of the law, these lawmakers, with what intent the law has been enacted. What was the background behind such making an enactment? So that is the preamble. Okay. Now,
so I would, ma'am, it is like something extra, but I would just tell the students one more thing. Since we are at the first class and many foundation students are there, like foundation students are obviously there, but many direct entry students are also there. So do you guys have any idea that how an act is formed? Respond please fast.
yes, because this is also one of the things that is required to know because you are studying the law. So that is
Okay,
also the
one
thing.
has responded no. Any other student, if two to three students will say no, I will just explain that how an act is formed. Okay.
Since the act is not formed in a day, you my dear friends, it's a
Okay,
lot
Jaya
of
knows.
working. Huh?
Jaya knows how it is formed. Jay, can you brief the students? Okay. Okay. Got it. Jay, would you like to explain to everyone so that I can unmute you? Yes, Anubhav, that's why I was thinking that you may not be able to know that what is the meaning of section, subsection, clause, etc. That's why I have taken up this thing that, okay, Jaya has not responded anything to me. Ma'am, my mic has some problem. Okay, Jaya. Okay, not a problem, beta. Okay, Kinari Kesharia. Okay. So Kinari, wait, beta. Okay, unmute yourself. I have allowed you.
Good evening, ma'am.
Good
Good
evening.
evening.
Ma'am, I pretty much know the brief. Please correct me if I'm wrong. First, the bill is drafted by the necessary executives and legislative teams. Then it has been presented in the parliament. It is approved by the Lok Sabha. If some changes are recommended, then again it goes back to the legislative. Then the recommended changes come in force in the Lok Sabha itself. And then when Lok Sabha approves it, it passes to the Rajya Sabha for further approval. Once Rajya Sabha approves it, then it goes to the president for its action.
And
Correct.
okay, so is the act formed? Let me tell you one thing. You are missing out one last step.
Otherwise, you have told it correctly. So last step we will tell. Otherwise, you are correct. That first, please mute yourself. First, a draft bill is proposed or made. There is a preparation of the draft bill. Then that that draft bill is like put in front of, or the correct word that is used is the bill is introduced in the Lok Sabha. Then it goes for very many rounds of discussions, first round, second round, third round. Once it is done, then it has to be passed by both the houses of parliament. And only when it is passed by both the houses of parliament, it is sent for the assent of the president. Once the president has given the assent to the proposed bill, it becomes an act. But there is one more step before it becomes an act. And that step is it has to be published in the official gazette. Until and unless it gets published in the official gazette, it does not become an act. And that's why many a times you would see, if you would have not noticed it till now, start noticing it from now, that they are saying bill like somewhere like 2019, but when it becomes an act, the time period would be like 2020, 2021, 2022. So that is the time when the bill has actually become an act, that year would be given to it.
Even you might have come across with the title, the Companies Amendment Act, either 2019, or it may be 2020 or 2021. So what does it mean? Is it the act? If it is an act, and what about the Companies Act 2013 in that case? So my dear friends, again, one more thing or updation in your knowledge that would like to add is that whenever you read any act nomenclature as the Companies Amendment Act 2021 or 2022, whatever the year, so this is not the original act. This is the amendment made in the parent act, that is in the original act, in the year, whatever year has been specified in the title. So many times, many amendment act has came in the Companies Act 2013. So many amendments have been made through that amendment act. But yes, still it's the Companies Act 2013.
Yes. So amendments are made in the original act only. Though they are said as the Companies Amendment Act 2020, 2017 Amendment Act, that's the journal way of saying things. But when it has become an operational, those amendment acts also, they are incorporated in the earlier or the main source act. And I would like to say to few of the students, it's not National Gazette, it is official gazette.
Yes.
Okay. So
the correct word.
Yes. So we and came into force in 2017. No.
It was Amendment Act, dear
The
friends.
Amendment Act came into force in 2000. There was an Amendment Act of 2017. But if you see, that is a part of the original act only. The provision that got amended, now they are part of the original act. Okay?
And that is why still there is the Companies Act 2013. Whatever amendment has been made, that is made in 2013 Act. So remember this thing. This is just for your knowledge, because
Yes.
many times students are confused. So that way, this is the one of the important aspect that we have discussed. And moving forward.
Yes.
Yes. Now let's start with the main. Okay, the main, you can say the content of the chapter. So you must be seeing that preamble already told you. You know about the preamble already told. So what the preamble has been specified for this Companies Act?
It is an act to consolidate. The words here are kindly when we are remember and repeat these words. So an act to consolidate and amend the laws relating to the companies. This is the exact line that has been written in the law.
Yes.
Act.
Yes. So here, what does it mean? That Companies Act, when it was made, with what intent it was made? It was made to consolidate all the company laws, because this was not only the first company law. 2013 was not the first company law. Before coming into the enforcement of this 2013 Act, there were several, Companies Act before this also. So if you're seeing, there were 1956 Act was of course there, which was a 57-year-old law, and it has been replaced by this our present Act 2013. And before 1956, there were other acts also. the Companies Act 1913, or you can say of something like 1866
1882
or
was
1882. And before that, yes, there was an कहते हैं ना, English company law was there with the
Yes.
name as Indian Company Law, which was based on the British Act. So in this way, this journey has been, that covered and finally resulted into the Companies Act 2013. So that is why consolidate. Consolidate means to consolidate all the laws and amend. Amend means update, because to in line with the recent developments and requirements, it has been updated so that companies in India are governed, under a single act or statute in the modern times.
So the
This is the
earlier act
preamble.
also was good, everything was fine, and they could have made the amendments. Like we have been teaching you that amendments. What happens is when there are too many amendments and the legislative people feel that there is now a need for the act to amend as a whole, because many of the provisions may have got repealed or are not relevant in the modern times. At that time, they may take a decision to upgrade the act by a new act altogether. I'm using the word act. The correct word would be the legislation.
Even many of the provisions which were earlier there in the Companies Act, but now they have been taken from there and a separate act has been formed. For example, if you see, earlier the provision related to voluntary liquidations, you would be finding itself in the Companies Act, but now a specific act has been made to regulate these nature of the, you can say, the nature of the companies, if such is the situation with the companies. So now the liquidation part has been covered under the Insolvency and Bankruptcy Code 2016. Similarly, if you see for the securities regulating things, so it has been specified under SCRA or the SEBI Act. Similarly, you would be finding where there is a DMAT with respect to online registration of the securities or purchasing of the securities, and there's the Depository Act. So you'll be finding there are now separate act individually focusing on the particular aspects. Earlier, everything was within the one act, or somewhere act has become so bulky, and that is why what happens, there was a delay in making the judgments, or you can say in the procedures. And that is why our legislators thought these things, why there is so much pendency in the tribunals or the courts, and so they thought to come up with the one single modern law specifically focusing on the Companies Act and its regulation, as well as also came out with the different specific act regulating the specific situations of the companies.
Yes. So this was about the preamble, and then we have the enforcement of the act.
Yes, already discussed. It got the assent of the Honorable President on 29th of August, okay, and notified in the official gazette on 30th of August. And most important thing, that is this, with respect to different provisions has been enforced on different point of times. The whole Company Act was not enacted in its entirety in one single go.
It was enacted in a single go. However,
it was enacted, but
the provisions were not notified in a single go. Like if you see further, we are writing that it contained 470 sections. So it was not that all the 470 sections were enforced on the day one itself. No, it was done in a phased manner. Like earlier 2 sections, then 98 sections. Then
yes. So what they did, Shata, just students must know. This on 30th of August, they came out with only section 1.
Yes.
And section 1 specified the name of the act. Yes, this is the act. It came out with the extent that is applicable to the whole of India. Then it came out with the commencement. Commencement means from which date, which sections will be applicable. So they have nothing specified. Then later on, 2 different notifications, they came out with the enforcement of different provisions in a phase manner. So this was the thing. And as of now, most of the sections of the companies are being enforced. Few are left, a few has been repealed. Yes. A few has been taken and out in some other
We can say that few of the provisions have been repealed also. So out of 470 sections, you may get confused that whether they are notified or not, but to go now, let's move ahead with this. So it has 470 section, and it is divided into 29 chapters. So the chapters that you have in your study material are almost aligned with what the chapters are there in the Companies Act 2013. Like I said, for the companies incorporated outside India, I told that chapter 22 of the Companies Act 2013. Like, so that is, if you see it, do see today at MCA that how they are writing, that's your homework for next class. I will ask that who all have seen it. So 22 chapter is related to that. Now chapter 9 of the Companies Act is related to accounts of companies. Chapter 10 of the Companies Act is related with audit and auditors. So in the in the books you have for any subject, for ease of doing and understanding, what we do, we segregate certain topics in chapter wise. Similarly, the provisions of the act has also been segregated and consolidated for ease of reference, and they are referred at one place in the sense of chapter. So these are those chapters.
Okay, and one more important aspect that is given is that every chapter shall be having at least one set of rules. Again, there's a new terminology, rules. Now, what is the difference between act and rules? Any of you? Yes, students, come forward and please reply to the queries to make this session more interactive.
And these are the things nobody will be asking you in examination, that what is the meaning of rules, what is the meaning of schedules. It's more of a kind so as to make you acclimatized with the subject, because these terms will be repeated very often. Okay.
Okay, if we talk about the act and the rules, the basic difference is you'll see what is an act. Act is what the law is. Okay, and this is what which has been passed by the parliament. That is the act. Okay, and rules is when you need to bring that act into action. That means implementation. So that is the rules. So this is being, who passes the rules, who makes the rules? It is the government, the central government or the state government, depends at which level the act is being passed. If it is a central act, then of course the central government. So this is the difference, that act is being passed by the parliament. Okay. Yes. And act is, supreme. You can say over the rules. Wherever there is a contradiction between the act and the rules, so of course there the act will prevail. Many students must have seen that somewhere there's a difference in the act and the rules. Two different things are being said, something contradictory or inconsistent. So at that situation, what you will be going to do? You will be just seeing what the act says. Okay. So that is why act is over, you can say it's overpowers, or it is more, you can say, of value than in comparison to the rules. Okay.
So what happens is, if we take it, this was a very legal explanation what that ma'am has given. To make it simpler for you, what happens is, when an act is made, we just read that how an act is made. An act is made like bill is to be passed, is to be presented, then both the houses of parliament are to pass it, and then president accent, official gazette. It is not as simple as we can count the steps on fingers, because sometimes it takes years and years.
That is, it takes a lot of working is there. Many committees are being formed, many experts are being involved.
Yes.
And day in, day out, they have a lot of discussions, and they invite the stakeholders, that opinions also, their suggestions also, and from the industries, the way corporates, in order to bring the practical utilization of the act. So that is an act. Act takes time, as Shraddha said.
If you have to amend the act, it will take a lot of time. It is not an easy task. So what is done? A set of rules are made. What happens is, the Companies Act was made, and at many places you will be reading that it contains the line as may be prescribed. Okay, so that as may be prescribed means that for that we have to refer the rules. The basic act is made, but how that will be made operational, or I can say a detailed guidelines to support or explain that act, are given with the help of rules. Why those said these guidelines were not made a part of the act because of the difficulty in changing.
Because
Like
it takes time.
it takes time.
And it got some procedure which needs to be followed. So in the case of the rules, you'll be seeing simply central government
Yes.
following its process, and within the less time they can decide, the concerned department under this authority, they can make the amendment in the rules, and via rules they can make any kind of the thing which is being required to be considered in present time or scenario, or as per the changes recommended.
So generally, if you see the amendments that are given, they are not directly into the act, but generally brought about through the rules for changing the act. So it will not be changing the whole line in the act. It will be like the as may be prescribed may be changed. And this is what we will give you an example of this while we will be doing small companies.
Yes.
You will see how this is very
Small
important.
companies there under the subsidiary holding companies, where you are
Yes.
finding these layers of companies. Then again, it is being prescribed through the way of the rules.
Yes.
What shall be the layer, the restrictions. So
Yes.
at many places, since you will seeing that companies has a rule-based legislation, everywhere you must have heard this thing. So that is why it is being regulated, and you can support it by through the way of the rules.
Yes. And then the act is also having 7 schedules.
Yes.
So these are supporting, or they are very, and schedules are very much part of the act.
Yes. Moving to the next, already this has been explained to you, so I'm not focusing on this particular part. Okay.
And you just need to remember that it extends to the whole of India.
Yes. Now moving to
the next topic.
Yes.
Which is your applicability of the act.
This is also one of the important things, because whenever any act is passed, it is also being regulated on what all this act is applicable. Okay, so here the applicability has been provided. So first thing you would be seeing are the companies incorporated under this act or in any previous company law.
So the Companies Act 2013, and like we gave you a brief background, like the 1913 Act,
Yes.
or 1956
1866 or 1882 or 1913 or
so this
56,
act,
yes,
so
1956.
so this means the companies that are incorporated under the Companies Act 2013, or if they were incorporated and registered under any other previous law that we have just told. Okay. Then
next,
it is applicable on the insurance companies, the banking companies, companies engaged in the generation or supply of electricity, any other company governed by any special act, such body corporate incorporated by any act for the time being in force as the central government may specify. So this may specify will again be dealt with in the rules.
Yes. So let's try to understand in the difference in these two parts.
Yes.
Because students are being not able to make it out. What is the difference in these two applicabilities given over here?
Yes. Any other company governed by any special act, or body corporate governed by any act for the time being in force.
Yes. So you would be seeing there is the term any special act. It's very clear, if any company is formed or being governed under special act, so that company will also be coming under the purview of the Companies Act 2013. On that companies also the Companies Act is applicable. So what all the example you would be seeing, what are all the bodies or the companies which are though not being defined under the Companies Act but are being governed or being formed under the Special Act or being regulated under the Special Act, that are also, on that bodies also the Companies Act is applicable. So you can find out various examples are there, like LIC, okay, Life Insurance Corporation, being regulated under the specific act is there, okay, the LIC Act of 1956 you will be finding. So here this is a special act.
Yes, they are governed by special act.
Or either it may be SBI. Okay, this is also a company which is formed under a special act, SBI Act 1955. And many more examples are there. And
so I'm getting a query from the students with respect to banking companies and everything. Yes, banking companies are also governed and insurance companies are also governed by special acts.
Yes.
We are saying that. So this definition has to be read with one more line, which says this provision, not a definition, except in so far as the said provisions are inconsistent with the provisions of the Insurance Act, Banking Regulation Act, and Electricity Act. So, though they will be treated as companies here, but if there is a provision which is in, there is a contradiction or inconsistency between the Companies Act 2013 and the Insurance Act or the Banking Regulation Act, then that will prevail.
Actually, their Companies Act provisions, the Company Act is generally laying down, you can say, general laws pertaining to the company's functions or
every type of
management.
company.
Yes. So, but there is a specific act, as you said, for the Insurance Act 1938 or the Banking Regulation Act 1949. So you'll be seeing that these are the specific acts governing these companies. So these Companies Act is applicable. But if anything is inconsistent, then we will go as per what the specific act says about. Otherwise, these Companies Act 2013 will be applicable on these companies also.
And if they would not have been like special type of companies, if you see insurance companies or banking companies or special type of companies, then there was no need to write it separately here. They could have simply written any kind of company. But and if you see, there is one more thing. The insurance companies or the banking companies are not incorporated under the Companies Act, but in order to bring them under the purview, not exactly the whole of the Companies Act, but to make them the provisions of the Companies Act 2013 applicable on these companies, they have been brought under the ambit of applicability of the act.
Yes. And you would be seeing the next category is such body incorporated by any act, not under the Companies Act, because it is using the word by any act. That means not under specifically under the Companies Act, but they are still the body corporates, okay? And they are being recognized by the governments. So you would be finding like example, would be seeing, for example, you can be see like IFCI, Industrial Financial Corporation of India. Okay, this is one of the company which will fall under this category, or ONGC. This is also the company which is not formed under the Companies Act, but yes, these are being recognized by the governments.
Like these are like the act is applicable on these also.
Yes, through the way of the regulations of the RBI or through the Companies Act, the provisions of the Companies Act are also being made applicable on these companies. So no specific act is there for this, but through the way of the regulations, they are being made certain guidelines applicable on these companies through the way of the Companies Act or through the way of the RBI guidelines or regulations.
So Hina is asking, ma'am, we have to write what's there on the screen, or will you specify? Beta, please, what do you want to ask? Actually, we are explaining what is there. And you cannot, like I have told you in the first lecture also, in the introductory class, you cannot write the answers like this. For that, you have to read the study material line by line. Okay. These pointers are given you from the point of easy understanding and retention. However, when you have to write it in your examination, you have to write the full lines. If I say, man, just give me a moment.
Yeah.
So if I have to write it in this sense, then I will be writing. This section also specifies the date of the commencement of the act. Accordingly, this section shall come into force at once, and the remaining provisions, like this is the way. The section furthermore states of the applicability of the act. The provisions of this act shall apply to. If you have to write an exam, you have to write the provisions of the act shall apply to number 1, companies incorporated under this act or under any previous law. Then the second point would be insurance companies, and if like this is the way you have to write it. Okay. You cannot just make the diagrams. This is for your easy So you mean कि बेटा अनुभव?
चलो ये बता देते हैं, अनुभव का भी क्वेरी सॉर्ट आउट कर देते हैं. Anubhav is asking about what is the meaning of section, subsection, and clause. Dear student, if you would have seen the act is divided into many parts, you know. So that parts, the main part is the section, okay. And when the section is further divided into subparts, so that is subsection. And further, if the subsection is also, you can say, divided into certain smaller paras, so then smaller points, then that is also known as clauses. So you can say the first act, and within the act you will be finding sections, because act cannot be laid down in a, you can have one paragraph or a single document. So what they do, they just divide into chapters with the different topics, and within the chapter each and every provisions is given through the way of the sections. They are divided into the sections, and that sections where it contains into various points, into many points, is being divided. Then it comes the subsection into the picture, and when subsection also contains further subpoints, or the you can say the different paras, then it will be termed as clause.
So I have just written it for you people. Like if it is written 23, 1, 3, 2. So 23 is the section. Then this one is a subsection. Then the next is a clause. Then this is like, after this is a subclause. And then there is one more thing that can be a proviso, which is a kind of exception.
Explanation is there.
So we will be dealing with it as and when it comes. So you were asking one more thing. If you see the exact line of the act, it says a company is incorporated under this act or under any previous company law. Then number 2, insurance companies, except in so far as the said provisions are inconsistent with the provisions of the Insurance Act 1938 or the Insurance Regulatory and Development Authority Act 1999. Then see, banking companies, then again they are writing except in so far as the said provisions are inconsistent with the provisions of the Banking Regulation Act 1949. So that you understand it easily, that's why we have given it in pointers. Okay. I hope so. Now it's clear.
Yes. So shall we give only one example, not focusing on, because it is all already given for your reference. You can later on reference the notes for your understanding. So here we are given certain examples of the different, because if there be repetitive times, there is a repetition of the definition everywhere, in what sense it shall be construed, then definitely it increase the size of the act also. So that all to avoid, there has been provided a one definitional clause where all the relevant definitions are being, given over there. So whenever the terms are being frequently under the act at any place, that in what sense it will be construed, that has, in that manner only, in that sense only, that term has been defined, and you have to take in that sense only that particular terminology in the statute.
Okay, so supposedly a term is defined in the definitional clause, but while reading a section, that term is again defined in a different manner. What will happen? Like the word total voting power is given. If in the definitional clause it means XYZ, and while you are reading it again, it has given some other meaning in that particular section, what will prevail? We just dealt with it. What will prevail? Specific or journal? Yes, correct. The specific section's meaning will prevail. Okay. Always remember, specific section will always prevail over the journal meaning. Okay. And remember these lines because they will help you while you will be doing your interpretation of statutes.
Yes.
So here what we are telling you somewhere will help you in the interpretation all over the acts, every kind that we will be dealing. The meaning provided in the section, correct, Shoaib. That's very good, very good. So our students have understood.
Very good.
Good.
So,
Medha, correct.
Yeah. So moving to the further this definitions. Okay. So
One
you want
thing.
to say?
Yes, I want to say something. So it says section 2, 95 clauses. Got it. Just a moment, students. Yes, students. So if we see, the WhatsApp group link will be shared by the technical team. So if we see, we are saying section 2 definitions, 95 clauses. So the word here used is 95 clauses. I can say, ma'am, 95 subsections. Can I
No.
say that?
No, because the act specifically says clauses.
But ma'am, here I read that, where we read beta? Ma'am, here we read that, oh. So here I read that section is to be, yes, that's what I'm saying. देखा बच्चे ने भी बोला है मैम,
हाँ,
बच्चा भी
तभी
मेरे
तो
साथ
बता
है.
रही हूँ कि एक्ट में क्या कहा गया है. वी विल गो विद द एक्ट, क्योंकि एक्ट के ऊपर कोई भी नहीं है. एक्ट इज सुप्रीम लॉ. So whatever the act says, we will go by the act. Act
Yes.
says it clauses, so I will go with the word clauses.
So all over the Companies Act 2013, whenever a section is followed by a number, a point, it is subsection, except in the definitional clause. So in this, when we will be doing, like here, it is 211. Common parlance में people may say
Subsection.
that section 2, subsection 11. But in the definitional clause, you have to say section 2, clause 11. Repeat after me. Section 2, clause 11, section 2, clause 11, section 2, clause 85. You can write it as 285. But when you will be talking to someone, talking to your CA friend, you will be saying 2, section 2, clause 11. I hope it's clear.
Yes. Sure.
Great. Is cheese, ma'am, session stopped on YouTube. Okay, I will inform the technical team. Can you repeat, please? Okay, what I was saying is, I told you that if it is like, had it been section 3(1), so I would have said section 3, subsection 1. But when I am saying about section 2 of the Companies Act, and it's like 211, I will say section 2, clause 11. It is a kind of exception. And in many of the acts, you will see in the definitional clause, like we will keep on repeating, in the definitional clause, in the definitional sections, always the subsection is known as clause. It is always said clause.
There's one more terminology. Okay, up till now you have come with the section, subsection, clauses, and so on. But there's one more terminology, article.
कंफ्यूज हो जाएंगे बालक
नहीं, बच्चे कंफ्यूज नहीं होंगे. I'll make
They are
them
intelligent.
they are, of course they are intelligent. Even we want our students to be intelligent, think out of box. This is something we are looking for and expecting from our CAs, coming CAs, okay, future chartered accountants. So article, you know,
Good show.
आर्टिकल आपको मिलेगा कंपनीज एक्ट, कॉन्स्टिट्यूशन ऑफ इंडिया के अंदर. देयर यू विल नॉट बी फाइंडिंग सेक्शन एट ऑल, यू विल बी फाइंडिंग आर्टिकल. तो ये भी एक तरह का नॉमेनक्लेचर है टू रिप्रेजेंट द एक्ट इनटू डिफरेंट पैराग्राफ्स rather than just giving over there the sections. You will be finding here there the articles. Okay, so I hope this is clear to you. So this article is also one of the terminology.
These are not articles of association.
No, Prajapati, it's not like that, Mrs. Prajapati. It's not like that.
We are just telling you ki whatever that specific act wants you to say, you have to talk in that language.
Everywhere here in the Companies Act, you are saying section 1, section 2, section 3. But in the Constitution of India, which is the supreme law, which is the mother of all the laws, You know, it is the supreme body over all the other laws is the Constitution of India. जिसे हम कहते हैं सुप्रीम, सबसे ज्यादा सर्वोच्च, that is हमारा भारतीय संविधान, which is the Constitution of India. So there you'll be finding that different provisions has been given under the naming articles, Article 1, Article 2, Article 3, in this way. So this is the difference. And after this, there are act, and after act, you'll be finding other bifurcations. So that is the supreme law is always the Constitution of India.
And in definitions, there is an easy way to remember that these are known as clauses. Reason being, when you are reading a section, it will be dealing with a particular thing. It is just to make you a bit less apprehensive that why this is clause. Okay. So when you are reading a section, if it is dealing with prospectus or if it's dealing with the registered office, okay, so all the provisions will be technically more or less dealing with that registered office only. But when you are doing the definitional section, what happens is all the clauses are different from one another. They're not related to each other. Okay, there is as such no linkage. So you can remember it in this sense also, that since they are very different from each other, this is just to make you like, okay, why? I'm not saying this is the exact reason, but it will make you a bit less apprehensive that kyun will be shant in your mind. So remember it like this.
Chalo, now let's move to the
Yes.
definition. Yeah. So here we started with the definition. We have not arranged in the serial order, but we have.
Okay. Okay. Ishwarya is saying, can we repeat in English? Articles is basically a term used in the Constitution of India, like in the Companies Act or all of the other legislations. We use the word sections. In simple layman terms, I'm telling you, but the Constitution wants you to call them as articles. There is a different reason behind it. I'm not going into that, but we are telling that whatever the acts want you to say, you have to talk in those terms only.
Yes.
I hope Iswara is now clear. Okay, let's move further.
Okay.
So since we are talking about companies, so first is your 211. Okay, why was there is a need to have a Companies Act? A brief background will help you in this also. Why did we need an act, like we said, to consolidate and amend? Okay. Basically, what happened is to regulate the companies. Okay, very good. So, had there not been any kind of act to for regulation, people would be, we are dealing with, the company is dealing with the money of the people. Company form of business deals with the money of the people. So there is a proper need for regulation, checks and balances, and if they do not follow that regulations, they will be penalized. So that is the brief idea behind that, why the Companies Act was needed, so that all the companies follow a single path of regulations. So
in
now,
fact, we can say they companies act as a kind of a control to regulate the company in a transparency,
yes,
accountable, and fairness
yes,
in the way of this
so
to protect the
investor,
investors' rights.
editor, that is,
Yes.
regulate companies. That is the best answer, because we are talking only in terms of that. Why? Because people's money is very much involved in it. Okay. So
Now
first
moving
definition
to this
is,
definition, and this definitions first we'll be taking some of the common terminologies which are used everywhere. The first we will take these definitions. So it has not been organized serial wise, considering what are the terms you should know first in order to go with the further the specific terms wherever these terms are also being coming frequently. So you'll be seeing first we'll be taking up section 2 clause 11 body corporate. Okay. So why we are reading this one, so that you are able to retain at the same time the sections also, along with if required the clauses, if
so
you are able to.
way we told you in the introductory class, the way you have to read it, As per Section 2, Clause 11, body corporate or corporation means.
Yes.
If you keep on reading like this, you will remember at least few of the sections. Okay.
So you are seeing that body corporate or corporation includes, again, those who have gone through the interpretation of statutes, and if not, please read this chapter, because there in the definition clause we have used certain words like means, includes, means and includes. So what all does this means in the definition? So here the term you are seeing includes. Includes means the meaning is not limited. That means whatever is given over here, that plus something other than this.
What you mean in journal terms as a body corporate or corporation is definitely there. Then the act is specifically telling you to include this also in the definition of body corporate or corporation.
Yes. So what is body corporate? Body corporate is though not defined anywhere in the Companies Act as such, but if you see, the word body corporate has been defined through the decisions given under various judgments and the case laws. So where they have said that body corporate is a legal entity.
Yes.
Okay, which is separate from the person who owns or manages it. So they have their different identity. So they are the body corporates. So they said that body corporate includes yani ki that legal entity we are talking about, and along with that a company is incorporated outside India. So those companies are also being covered under the body corporate. And it also specifies that it does not include. Matlab, it is clearly specified there are certain nature of the companies which are not being covered under the body corporations. Okay, so they have specified cooperative societies who are being registered under the cooperative societies, and any other body corporate which the central government by notification specify and which are being not defined under the Companies Act. So that companies will also be excluded from the purview of the definitions of body corporate.
So it has two limbs to this definition. One is they're saying it includes that whatever you understand in the common parlance as a body corporate, definitely you should take it as. Then it includes, what does it includes? It includes a company incorporated outside India, but it does not include cooperative society registered under the Cooperative Societies Act and the any other body corporate which the central government may define by the notification. So these, it has includes limb and the does not include. This definition is like providing a wider coverage to the term body corporate, which you will understand when we will dealing with the next
company. But before that, these are the few examples for your reference, which you can refer and already have been earlier given about these kinds of the, the companies which are being not defined under the Act or which are being governed by the Special Act, and though not being defined under the Companies Act, but through the notifications by the central government, it has been specified.
Okay.
So this you can refer. This is given for your reference. Okay. Now moving to the next definition,
which is your, let's repeat with us.
Yes, section 2.
As per section 2, clause 20, company means.
Yes.
As per section 2, clause 20, company means.
Okay, now it says the word used is means. Earlier what we have seen includes. So it was giving a broader coverage.
Yes.
But now here it is talking about means. Means means limits. Limited to the meaning, or limited to whatever has been defined exactly in the Act. Okay, so this limits the definition actually. So you are seeing that company means a company incorporated under this Act. Okay, yani ki 2013, and under any previous company law, whether it be 1956 or any other acts that we have already discussed earlier. So companies, whether it has been incorporated under any previous law or under any this present existing law, in that case it will be termed as a company.
So here one thing that was to be seen was the word means, and the other word that is to be seen is or. It's not and, it's or. That means it's giving a wider coverage. Either this and more also.
Yes.
Incorporated under this act, or जिसे हम हिंदी में या कहते हैं, अथवा कहते हैं, not and but it's or.
Yes.
Under previous law. So let's understand this by an example.
Yes, you can see there's a Reliance Industries which was incorporated under the earlier act. Okay, it was incorporated in 1973. So for that, which act was there? 1956 act was there. Similarly, the another companies, their year of incorporation is given. They all are being incorporated under the earlier act. So in such case, you'll be finding these companies will also be set to be a company under the existing company law, that is the Companies Act 2013. There is one thing, student want to know what is the difference between company and the body corporate. Yes, this is the confusion. One, we are just limiting. Yes, company will only include this thing. Only specific. We are defining certain specific things only to be covered under the definition of the company. And in the body corporate, we are saying along with that inclusions that the company is incorporated outside India, there are certain other companies also. So you'd be seeing, since specific thing is there, the company, so you can say every company is a body corporate. क्योंकि आप देखोगे ऊपर definition में मतलब include दिया हुआ है. So it means it is not restricting to any other company. So we can say means every company is a body corporate, but every body corporate may necessarily not be a company.
So a body corporate definition is providing more flexibility. It is covering a wide range, okay? And to cover every kind of corporate entity, okay? Every kind of corporate entity would be included under the ambit of body corporate or corporation. But when we are dealing with company, it is narrower because it specifically tells that anything, the companies which are incorporated. So incorporation under this act or the previous law is very important to be categorized as a company under the under section 2 clause 20.
Yes. ठीक है, I hope this is clear.
Any queries? Correct, Prajapati, this is correct. Company incorporated in India, it also includes in the definition of body corporate.
It's given in the definition already.
जो आप, if I tell in simple, whatever you mean by a body corporate in normal sense, that is obviously there. But what you do not mean, the act is trying to say that even if you do not consider a company incorporated outside India as part of a body corporate, it is very much there. Okay.
Yes.
What is not clear? Okay, clear. Very good. Yes, a company incorporated inside India is a body corporate. Incorporated outside India is a body corporate.
Yes.
Because the term used is includes. Okay. But the includes and behalf तो कुछ नहीं. Okay, clear. Good. Very good. Okay. And so for most of the students, it's clear. So we can move further. Clear. Very good, students.
Okay, moving to the next is promoter. Okay, this is again very important terminology that you must be hearing a lot under the companies. At various places, you may be looking this particular terms or the persons. So what the word promoter says about, you can see a person. Okay. First, the promoter should be a person, which means like again the limited definition is given, means only these people who has been specified will be considered as a promoter. So who all are those persons? It is clearly specified who is named as such in prospectus. Okay. Then who has been given in the annual return, whose name has been identified in the annual return, or who has control over the affairs of the company, or even on whose advice, direction, or instructions the board of directors of the company is required to act or accustomed to act. So such person shall be termed as a promoter. Very clear definition is there.
So
Okay.
if I have to understand it in normal terms, if I ask you students that who is the promoter, you must have seen so many of Shark Tank things that are going on. Good, so it's clear. So a promoter is a person who basically conceives the idea of forming that company. Okay. Plus, so if I think, okay, ma'am, I want to open a company for modern apparels, will I be called a promoter? No. Then I have to take steps to bring that company into existence. So the main points are a person who conceives the idea of forming this company and takes necessary steps to bring that company into existence. Then that person who is basically the founder or the initiator of the company will be termed as the promoter.
Word itself is promoter. That
Promote.
Yes.
Is he the owner? Not
No.
necessarily. Not necessarily.
It depends, but yes, if he is acting in any of the capacity or in any of the form, then he would be termed as a promoter, and this means it is clearly defined, and no other than this the person can be termed as a promoter.
Okay, so what the act is saying, what I told was in a journal sense. So what is the act saying?
Yes, even you could be seeing a provisions there to the last point.
So the act is saying a person who has been named as such in the prospectus. Now let's come on to how you have to learn it. First of all, it is very necessary that person should be named as a promoter, named as such. The word they have used is as such. So that person should be named as a promoter in the prospectus, or the word uses not and, but unable to join on Zoom. Just put in your, go to the website buslive.org, then or either join through the mobile app. You have to put in your credentials and then you can join directly on the Zoom, because I can see many students, those who have joined. Please try again, beta. Okay, so that person should be named as such or is identified by the company in the annual return. So somewhere it's saying the same thing, that they have to be specified. Identified here means that that person has to be identified, specified in the annual return. Okay, or who has control over the affairs of the company. Now the first 2 points we're dealing with, that they should be named as such either in the prospectus or in the annual return of the company. Then they are saying if any person has control over the affairs of the company, a company is newly formed and that person has control over the affairs of the company, how the company is run, and they are taking the strategic decisions of the company, then that person is also promoter. Or now the next 2 points are almost similar. In accordance with whose directions, advice, instructions the board of directors of the company is accustomed to act. Okay, so in what happens is in every family we go to a certain person with to whom we ask certain things, and we are very accustomed, we are very habitual of following what that person is saying. So similarly for a promoter, either the first 2 points that they have to be named somewhere. What are those 2 points? They have to be named. First is the prospectus, or is identified as such in the annual return. Or now the next 2 points are referring to the management. The first point was who control over the affairs that ma'am has marked, control over the affairs of the company, or in accordance with whose advice, directions, or instructions the board of directors are accustomed to act. See, ma'am has marked few things. Accustomed to act, board of directors. You should learn these words. Advice, directions, instructions, the board of directors of the company are accustomed to act. We will be referring to this line at n number of places in the act. So I hope so. It's not only clear, but you have learned it with us. Okay.
And then there's a proviso to the last point where you're going to act on the advice of any person to instruct the board of directors. So there is a proviso attached to that nothing in this section clause, the clause number last clause, shall apply to a person who is acting merely in a professional capacity. Suppose on whose advice you are working or following up the instructions or direction, and suppose that direction is being served in professional capacity, then in that case that will not be covered under this clause. That means that person will not be considered as a promoter if he is acting in a professional
capacity. So the word here is who is acting in professional capacity. Suppose you are the chartered accountant, like you have been enrolled by the company on the payrolls, or not on the payrolls, but for acting in professional capacity, and they are asking you again and again that what should we do in this scene, what should we do in that scene. There you are not the promoter if you're acting in professional capacity. But if you are a person who is having the control of the affairs, and the board of directors are very accustomed to act but not in professional capacity, then you will be termed as only as a promoter. Hope so it's clear.
Here are a few examples. So you can see here we have given in the example that Mr. High is there, who is holding 60% of the shareholding in the X company. So what does this shows 60% of shareholding? It reflects that you are having an effective control over the decisions of the company, because due to major shareholding, you are having the control over the decision making of the company. So because of that, you will be falling under the purview of the definition of the promoter, and hence Mr. High will be considered as a promoter in the X company.
Okay.
Okay.
Let me change it a bit for you. A consultant is a promoter, can be if he is not acting in professional capacity. But if the consultant is acting in professional capacity only, the word here I'm using is if he is acting in professional capacity only, then he will not be termed as a promoter. Mr. High holds 60% of the preference share capital in X company, and this preference share capital is not having any voting rights. Will he be having effective control? Will he be having effective control? Yes, no. You should have control over the affairs. It's not necessary that the preference shareholder will have control over the affairs of the company. If it definitely says that equity shareholders, then you will say yes.
And there's one more thing. Control. What does it signify? So you will learn further. There is a definition of control also. So you will find out how this control word regulates in this definition. So we will take up over there. But yes, effective control in the decision making, you can say, or in the management with respect to appointment of the directors and all these things, or with respect to their rights, then that is known as the effective control. Okay.
So since we have come this far and we have taught so many things, let's give them a 10 minutes break so that they can go about.
Member, and after member, let's give them the break.
Okay. You are okay?
Dear students, one more definition we would like to cover before giving up the break.
Okay, they are saying they are good to go.
Okay. So, okay, the next definition is the members. Okay. You can see another example also is given for your reference. Hmm.
Member.
Yeah. Now coming to the member. Again, the section 2 clause 55 reflects the term member. Okay. Again, it says in relation to a company. Member should be considered in relation to a company, not in relation to a person. It shall be in relation to a company. Always read the words. Every word had its sense and connectivity actually. So it means member in relation to a company means. Okay. Again, the limited meaning is there. Limited things will be covered under this definition. Okay, this says the subscriber to the memorandum. You know, at the time of the incorporation, when you just lay down the memorandum, which is the charter of the company, so there are the subscribers who are being involved into the incorporation. At the time when the company is formed, they just purchase certain shares.
Yes.
So they are known as the subscribers.
So you know that at the time of incorporation of the company, there should be at least a minimum number of members. Then only it can be incorporated as a company.
Yes.
So those are the subscribers to the memorandum of the company.
Then second category is every other person. Matlab, every other person who agrees in writing to become a member. ठीक है?
Who says that yes,
I want to be a member.
Yes, I'm ready to
and
become.
they just go into writing also. Remember, the word writing is there. Okay. Then third category is that every person holding shares of the company as a beneficial owner. Remember that as a beneficial owner, he is holding the shares in that company. So you'd be seeing how they become the members. With respect to the subscribers, you will be finding on the registration when that company is being incorporated and registered, and at that time they shall be entered as a member in the register of members.
Remember this word.
Yes.
Entered in the register of members.
Yes. Unless and until they are not being registered in this register of members, they will not be considered as members. So members are the person who are registered under the register of members. They will be considered as members. So there's a basic difference between shareholder and members here. Shareholder are being not registered in the register of members, and members are being registered in the register of members.
So what happens is, today I purchased certain shares of the company and tomorrow I sold it. So it's not necessary that I am a member of the company. It's like I'm the shareholder of the company.
Yes.
Okay. So there is a lot of difference. Until and unless my name gets registered as a beneficial owner, you will understand all this later, because right now the things are like all online. So depository.
So whenever this chapter is going to come, you are going to read
7.
it. Yes. So there you will come across with this terminology.
So just keep in mind, it is not, though in common parlance we use the word member and shareholders
at many times at various places, but this is a basic difference.
Until and unless your name is registered as a member in the register of members, you cannot be said to be a you cannot be said to be a member of the company. In that case, you will only be a shareholder of the company. Okay.
Okay. Now moving to the next part, where every person who agrees in writing, once they have agreed in writing to become a member, and their name is entered again in the register of the members of the company, they will be considered as a member. And the main important thing is that they should be registered in the register of members. Their name should be entered over there.
So entry in the register of members is important.
Yes. Then next is every person holding shares of the company as a beneficial owner in the records of depository. Okay, now there is a term depository. What is a depository? You have seen bank, how the bank saves your money. Similarly, this is the bank of
shares,
securities, because now in Companies Act, this is the word securities.
Correct.
Earlier it was shares, but now securities. Securities is a wider terminology. It includes the shares, it includes debentures. Yes. So depository is basically the bank of the securities, you can say. And there are two depositories in India.
NSDL?
Yes. NSDL and CDSL. Okay. National Securities Depository Limited And this is the Central Depository of Securities Limited.
So what happens is, why was this bank needed? Earlier, all the shares were held in physical form. You know, you guys might not be knowing, but earlier the shares were held in physical form and share certificate used to be given to the shareholders. I'm using the word shareholders, and they would become members because it would be entered into the register of members. Now with the stock exchanges, things coming up so fast, and it's like going on a click of a hand and the transaction is done. All the shares have been dematerialized and they are kept at this depository or the central bank, which is known as NSDL and CDS. So now when you are purchasing the shares of a company, it's not like you are buying or selling it directly from the company. What happens is all the shares are deposited with this depository, and now you become only a beneficial owner of the what? Shares. So that's why we are writing the word beneficial owner, because now a reserve has been created and things are moving added or taken out from that reserve, which is your depository.
Okay, now let's take examples and then we will take a break. So yes, here are the examples you would be seeing. Already explained you who are the subscribers, so no need to explain it again. But yes, let's take an example. Suppose there are three people,
Raja, Ram and Mohan, who have signed the memorandum of association of this Roy Private Limited, and they are dealt as subscriber to this memorandum of association.
Yes.
Okay. So, and they have agreed to take 1000 shares. So once the company is registered, they automatically becomes the members as their name have been, and first of all, they are a subscriber to the memorandum and their names are registered as members in the register of members.
Okay, so this is clear. How do you now let's take a further situation. Now, after Roy Private Limited is formed, then one Miss Sati is there who want to purchase or buy shares in the company. Okay. Now, what is she done? She has filled up an application and similarly the company allots the shares and her name is entered in the register of members. So, whenever anyone purchases the share and his name is entered in the register of members, then in that case, yes, the Sati has become the member because she has agreed in writing. Remember the word already given in the definition should be in writing. Oral will not work over here. Okay, so his name should be entered in writing, and when the name is entered in the company's register of members, she will be tend to known as the member. She will become a member of the company. So I hope this is clear.
The main difference, major, like if you want to understand the difference between beneficial owner.
Yeah.
Okay. Query has gone. From subscribers and shareholders. Subscribers of shareholder memorandum of association were the ones who subscribed to the memorandum at the
during the incorporation,
like
it is the initial stage when the company is being formed. At that time, subscribers comes into the pictures.
Okay, and beneficial owners concept you will understand better because there is a big provision.
Provisions, rules basically.
Rules. It's like 6-7 pages that you will learn in chapter 7, that is management and administration. There is a big provision that why these are known as beneficial owners. But in short, we told you it's because of the depository wala thing. Okay. And there are many other kind of beneficial owners. We have dealt with only one kind of beneficial owners.
And it is better to be taken up that moment time. Other you'll be again somewhere you will be just be out of your track.
Yes.
So we just don't want to be that. So would you like to take a break, Shraddha? Just a 5 minutes, and we can start up with these types of companies.
Yes.
Some specific types of the companies.
Yes, you can. It's already uploaded. I will check with the technical team. that if it's not showing to you, that why it's not showing, and then we can see that if not today, then I will ask the technical team to see to it again. Yeah, okay, because I'm getting this, so let me see that why it's not showing to you. So kindly bear with us till tomorrow.
So students, let's take a 5 minutes break and just come back again after this. It is 7:45. So yeah,
See you at 7:50.
50. Yes.
Technical team. Technical team. you after the break. So students, now move on to our next definition,
Yes.
which has been clubbed as per the types of companies.
Yeah. Wait.
Okay. So let's discuss the types of companies. So what do we mean by we are categorizing, like we are reading Companies Act again and again and again. We are trying to categorize the companies, that what are the various types of companies that can be categorized under the Companies Act 2013. So first term that we are referring is your one-person company. As the name suggests, one-person company. Companies, we were saying, is a lot of people have come together and pooled their money, okay, and that's why they are forming company, be it a private limited company or a public limited company or any other form of company. But now we are giving you a definition which is given under section 2 clause 62, and we are saying one person company. How can a one person form a company? It's a proprietorship firm.
Yeah. Reflecting to be same because
Yes.
it is being done by only one person as a member. So we are taking there is a sole owner of the company, and that is why we are considering here the concept of sole proprietorship.
However, the Companies Act 2013 introduced another kind of company, which is known as one-person company. So this is an extension, if I say, to the proprietorship firm, but it has been given a legal entity framework to this one-person proprietorship firm. But now we will be calling it as one-person company. It will have the benefit of the proprietorship firm as it will be managed and run by one person, but it will necessarily contain the basic features of a company. So one person company. So it is given under section 2 clause 62.
Yes. So basically, you can see कि whatever, since being a single person is.
Wait, it's not showing. It is not showing. Okay, thank you. Thank you बेटा बताने के लिए. Okay, now is it visible? It's still not visible? Yes, now it's visible. Visible. Now it's visible. Okay, thank you. So it is a one-person company. It means which has only one person as member. So the word here is means. So it is to be meaning this only. This only means, it does not say includes. It says means a company which has one person as a member. So repeat after me. One person as a member, because a company is made out of members. Okay. Why was there a need to have a one-person company? What happened was there was nothing like a one-person company under the earlier act. Either they have to form this sole proprietorship firm only. But in that case, what was the main problem? They could not have the benefit of the company form of business. So that's why they brought into a new form of company, one-person company. Okay. What kind of company would it be? Would it be a public company or a private company? Just let's not like learn all the things. Let's try to understand, and it will be automatically be in your mind. So So what do you think? It should be a public company, many members are involved, or only one person is involved? Basically, it should be a type of private company. Okay. Which can be started and managed by a single person. So this we have dealt that it is one person as a member and it is a type of private company. And who is the sole member as well as the shareholder? Because in this not many people will be there. They can employ people under them, but it will be basically he will be the member as well as the shareholder. He can employ employees under him. Okay. Now, if you remember in the foundation classes, you must have read one thing. Okay. And that would be that the company form of business has perpetual succession. I hope so. You remember? I hope so. That it is like you remember that every form of company had perpetual succession. That means the basic members, even when they go, the members, shareholders may come and go, but the separate legal, because it was a separate legal entity, the company form of business will keep on going. If we have to call this one person entity as a one person company, that means we need to have perpetual succession in this also. So if this, and if you see that we are saying that this person is the sole member as well as the shareholder. So supposedly something happens to this person, what will happen? Generally, what do you think should be like this? If some person is the single person, how can we say that this should have a perpetual succession? Okay, correct, very correct. So they should have one more person, or they should have a will kind of a thing. They should somewhere write that if I am not there, this person will manage it. Okay, you understand? We should have some other person who can step into the shoes of that sole person if something happens to that sole person. So this is basically the concept. So now let's read the provisions. First we have dealt, then the second is it combines the benefit of sole proprietorship with the legal status of the company. Okay, then
let's take this example also.
Okay, so this is like, suppose Mr. A alone wants to start a company, but also wants limited liability and a company structure. He registers Alone Enterprises, OPC. This is the way the name of our OPC is always written. State whether the company formed can said to be a one person company. Okay, yes or no. It can be because he is the sole member, shareholder, and he needs to appoint a nominee, which I was saying that someone should step into his or her shoes if that person is not there. So he should appoint a nominee. Say in this case, they are saying Miss Lonely, and then this company is treated as a separate legal entity because perpetual succession is necessary. So there will be a sole member plus a nominee is also very much needed. Rest of the litigities of this section of this concept will be dealt further in your chapter 2, which is your incorporation of companies. Okay.
Okay.
Is it clear?
Is there any query?
Nominee, correct. So students know this concept because they must have read it in nominee. Correct. So legal heir, no. Legal heir is not there. The
word is nominee.
Nominee. because it is not necessary that that person should be related.
one, yes.
And it is like it is not to be mentioned in the will.
Legal hair is given by the, some legally who all is going to be the representative of the deceased person. So they are the legal heirs, and legal heirs are through the way of the legal way
That
they are being
nominee-
appointed in such capacity.
This nominee is not necessary should be related by blood or something, and this nominee is not be mentioned in will or something, or it is like while they will be drafting the documents of this OPC, at that time only the nominee will be mentioned, and obviously they can change it. There are many more provisions related to OPC, and that you will be reading in chapter 2. Yes, you can write the definitions in your own way, the way we have told you in the first class also. So the next is
the private company. So you would be seeing there is section. Let's just take up this query because Anubhav is continuously asking about it.
Okay, so students, if sometimes yes, it can be a legal error. Sometimes if we do not respond to a query then and there, because it will impact the flow of the class. We generally see all the queries, and if we are not able, if we are not responding to it then and there, then we will respond it either in this class or in the next class, because it impacts the flow of the class. And this query we will take at the end of the session, Anubhav. Let's continue with the types of companies.
Okay, let's take up this query first. So he's asking about the schedule. What is schedule and how does it differ from between the schedule and the chapter? Chapter is very much clear. Broadly, a chapter, any particular topic has been divided into chapters. And I already said under the Companies Act, there are 29 chapters. The whole Companies Act has been divided into different chapters related to that particular, you can say, the nature of the business, or nature with respect to nature of, you can say, whether with respect to foreign companies. So separate chapters been allotted to it. Yes, all the provision related to the companies which are being dealt with, the companies incorporate outside India, separate chapters been allotted to them. Similarly, when there is with respect to management of the company, administrations of the company with respect to working part, definitely there is an allotted a different chapter for it. So that is the chapter under the Companies Act, broadly divided into different headings. But when you talk about schedule, schedule is generally being given at the end of the act, as told preamble in the starting. So this schedule is at the end of the act. What does it means? Schedule is basically it's providing an additional information to, you can say, the main text or the document of the statute. So it may be either through the way of tables. You might have seen the remunerations of the directors. I don't know whether you must not be aware of, but yes, you'd be seeing different tables are there in the schedule, or with respect to memorandum of association, but with respect to article of association, what shall be the format, what shall be the form. So they have been provided something additional information or details which are pertaining to the main text, because the related provision under section 5 memorandum of association, and that is what the related document is given under the schedule. So this is schedule means something additional information pertaining to the main text, or the, you can say, the act, or the document, you can say the main document, the Companies Act 2013. Okay, so I hope this is clear.
The student is asking, in case if a nominee has died, how much time will it take for appointment or reappointment of another nominee? These all will be
covered in the next chapter.
So
Yes.
great. And one more student asked a very good question. I'm just trying to find out. Can you, one of the student has asked about
What?
This regarding OPC. The student asked legal air wala thing. Can you, I'm just missing out who asked it. Kindly resend it. That if legal air has to be there or something, the student asked, you must be getting, the student must be knowing whom I'm referring to. Please ask. So no, not this. Then please ask it. I have missed the student's name.
Sure,
okay,
so let's move further. Yeah, private company.
Private company.
Yeah, so it is given under the section 2, where this clause 68. Okay, this is talking about the private companies. And if it is seeing what does private company means, okay, it prescribes that which having the minimum paid up share capital as may be prescribed. Prescribed means given under the rules. But as of now, there is nothing been prescribed under the rules as regarding the minimum paid up share capital holding.
Contact, please message.
So anytime if the government feel likes to introduce with this, the limitations with minimum paid up share capital, they can introduce. But yes, as of now, there is no such prescribed limit of the paid up share capital for the private companies. But yes, for private companies, now as of now, you need to see with the articles, what the articles prescribe, what are the restrictions, or what are the additional, you can say the conditions that have been imposed for any company to be a private company. So it says that it restricts the right to transfer its shares. This is the condition where the transfer of shares, this right is being restricted. Okay, and this is clearly mentioned in its article. Okay, then next point is limit the numbers of its members to 200. That means it has preserved the maximum limit that it shall be containing 200 members. Maximum limit is there. Fine, so it can be less than 200 but not exceeding 200. But again, it has imposed a condition when any person can be considered within this limit of 200 as a member. Okay, so it provides that any person who is in employment of the company, who is in present in the employment, he will not be considered as a member. And further, it says the next category is specified is the person who have been formally in the employment of the company and was member at that time. At that time, he was a member while in that employment and even continued to be member after even ceasing the employment. Okay, that means the present member as well as the, you can say, who was, yes, still a member but is not in employment as of now. So these two categories of person will be excluded to be counted as an, within the limit of being of the members.
200.
Okay, yeah. Then the third restriction imposed is that it prohibits invitation to the public. That means it cannot offer to the public for the subscription of the shares, for offering a shares basically. So they cannot invite to the public for this particular with respect to securities of the shares. So if these three conditions are specified in the article, then such a company will be said to be a private company. Okay, because many times the questions are being portrayed in the exam, they are testing on the basis of this numbers of members, and they give the different categories of persons over there. For any person who has been employment and who has already ceased but he's not a member, but he's a member still but ceased from the employment, and also someone that conditions may also be given that company has issued the this offers to to public the shares and all this thing, to whether such a company can be considered as a private company or not. So if you are being aware of the conditions, then you can easily be able to analyze whatever the information given in the question, and with respect to the nature of the companies they are asking for, you can give the answer.
So if I have to remember this definition, ma'am, how will I? What do we mean by a private company? Private company basically means something which is close. Private means close. So that means there should be certain, this minimum paid up share capital wala thing is not there. This is for your understanding and for your retention. Okay.
Yes, still it's being the part of the act actually. It's there itself in the act, though nothing has been prescribed as of now. So that is why it has been given over here, just to make it out what exactly the law is.
Like somewhere they can, after like 1
sometime
year,
maybe
they can say that, okay, a company having 1 lakh rupee or 2 lakh rupee paid up capital, nothing has been specified as of now, but they can. So now if it is a private company, what happens is they need to have certain restrictions which are not there for the public companies. So they are saying, if you see, all of these things are in the form of restriction, that you cannot transfer the shares. So there is restriction in transferring of shares. So students, the first point is restriction in transferring of shares. Then they are saying, okay, you can have n number of members, but that number of members cannot exceed 200. Then they are saying about transfer, you are not allowed to transfer. They are saying simultaneously, we are also saying to you that you should prohibit any kind of invitation to the public for subscribing of any securities. So all these three conditions are in the sense of certain restrictions, and it should be written in the articles. Okay, that has to be written in the articles. And then the exceptions have been provided. There are few more points that have been given.
This is with respect to shareholding. Suppose where there are two or more persons, okay, and they hold one or more shares in a company, that too jointly, then how you will be counting them as a separate members or a one members? The law clearly specifies that they shall be treated as a single member, and this is always being asked in the question also. One specified category of members are given of this with the persons who are holding jointly the shares. So there you need to consider as a single member, right? And there are certain exemptions to Section 8 companies, of course, and when that exemption is applicable, that is also given. So it is said that simple is that the requirement of having minimum paid up share capital, since in the Act for private company, the requirement of minimum paid up share capital is given, though it's not has been specified, but with respect to Section 8 companies, this requirement is not applicable. They doesn't require this requirement of holding of minimum paid up share capital. Okay, so Section 8 companies are basically the companies which are formed for charitable objects. They are formed for non-profit making, with the intent of that they are being formed such companies. And I would be seeing that this exemption to Section 8 companies again had one more thing, when this exemption shall be applicable to Section 8 companies. So it specifies that it will be applicable only when no default has been committed. You read the line where there is, where it is not committed. That means where there is no default in filing its financial statement or in filing of annual return with the registrar, then said this exemptions will be given to Section 8 companies. Otherwise, if this condition is not complied with, then no exemption will be given to Section 8 companies. In that case, it has to follow the requirements of the restrictions that has been given for private company. The same will be applicable for Section 8 companies. So questions may be asked. So read always the questions carefully, which nature of company they have given in the question. So read it properly, because they might confuse you. Giving over the Section 8 and mentioning that the company is not given the restrictions, not followed up the restrictions, and now they will asking whether what will be the nature of the company, and they can test you on the basis of this exemptions as well as its applicability.
So, ma'am, Nitin has said a good thing, ma'am. If he has not made, it is with respect to OPC. If he has not made a nominee, then will the legal heir carry out the OPC, or nominee appointing is compulsory? Nominee appointing is
कंपलसरी.
compulsory.
एक तो ये लॉ में बोला गया, दूसरा जो परपीचुअल नेचर वाली अगर हम बात कर रहे हैं, अगर उसको कोई कैरी फॉरवर्ड करने वाला नहीं होगा, परपीचुअल उसको आगे कैरी नहीं करे, तो कंपनी will lose its existence, and this is the requirement of the company that it should have it is permanent उसकी existence होती है. तो that is why we need somebody to continue with this particular business, and that is a nominee is being appointed.
Okay, so a student is saying a difference between OPC and proprietorship. So proprietorship is basically, if you see, OPC is a form of company and proprietorship is not. Both are run by a single member. In OPC, there is no legal requirement to have a nominee. It's not a company, but in OPC, it is a company.
Yes.
So proprietorship में ऐसी कोई concept नहीं होती है. If both member and nominee die, सब साथ में चले गए, कंपनी खत्म हो जाएगी. कंपनी वैसे लीगल स्टेटस कंपनी का एज सच नहीं खत्म होगा, बट देयर विल बी नो वन टू रन द कंपनी. ओके, ऐसे तो सारे शेयर होल्डर सब कुछ एक साथ ही चले गए तो किसी कंपनी में पूरा न्यूक्लियर बॉम्ब गिर गया.
इसीलिए परपेचुअल एक्सिस्टेंस का कंसेप्ट रखा गया, क्योंकि वहां पे जो पब्लिक मनी इन्वॉल्व है टू सेफगार्ड द इंटरेस्ट ऑफ द शेयर होल्डर्स, द स्टेक होल्डर्स. तो बेसिकली दीज कंपनीज आर ऑफ परपेचुअल इन नेचर.
तो देयर request you to, when you come for the next class, because you are asking again and again to explain the same thing. So I will ask you to read, come for the next, when you are coming for the next class, you can read all the provisions that you have covered today. Your concepts will be cleared. And still, if there is anything, we will take. So we are moving on to the next form of company, which is your public company.
Yes. Now coming to the public company, this is section 2, clause 71. Okay. Remember, it is very simple definitions. If you are aware with the public or private company's definition, you can easily write down and make it out difference with the public company. Because it says it means a company which is not a private company. Very simple. Whatever the restrictions have been imposed on the private company, if this conditions is not there, so that means that company is not a private company. If the company is not a private company, then it can be a public company. So public company means which is not a private company. And
Ma'am, एक second. A student is saying the screen is not visible. I don't think so. No other student has said it. So kindly see if the
kindly
connection
confirm anyone else also, dear students.
visible. So
Yeah.
okay, let's continue.
Okay. Then you will be seeing is not a private company and the word is given and. Okay. Matlab, along with these conditions, you are required to comply with this condition also and has a minimum paid expense. But yes, still as of now, this is not prescribed. So we can ignore as of now. Remember the word as of now. But yes, that
But if it comes to write the definition, then do write.
yes. So any company which is not a private company is a public company. Very simple definition. So read the private company definition carefully in order to understand this public company. However, there is a one important proviso attached over here. Questions are being tested on this proviso. You know, provision is something which is other than what the main law says. Matlab, something which is not falling within the purview of the main provision. That is the proviso. Proviso is a kind of the condition that has been imposed. Yes, because of this thing, this will not form, yeah, this will not fall within the, you can say, scope of the main section. So you see their proviso is attached over here.
It's a kind of exception.
Exception, yes. So proviso says that a company which is a subsidiary of a company, okay, not being a private company, मतलब वही चीज कि वो private company नहीं होना चाहिए, ठीक है, मतलब not being a private, जो private company नहीं है, ठीक है, shall be deemed to be a public company for the purposes of this act. ठीक है, उसको पब्लिक कंपनी माना जाएगा इस एक्ट के अंदर, where such subsidiary company continues to be a private company in articles. Let's take through an example to understand this. This provision is very important.
अगर simple terms में इस बात को बोला जाए, if we say it in simple terms, they are saying subsidiary of a company not being a private company. What is not being a private company? That means a public company. In simple terms, shall deem to be a public company. So this public company's subsidiary, okay, shall also deem to be a public company. This will have a status of public company, whether it is a public company or not a public company.
Now suppose, let's take an example. हाँ, देखिए यहाँ पे example दिया हुआ है. Just for convenience so that you can understand actually. There's Abhi Private Limited, which is a wholly owned subsidiary of Sabhi Limited. ठीक है, यानी कि क्या मतलब हुआ, अभी लिमिटेड होली ओन सब्सिडरी है सभी लिमिटेड की, यानी कि ये आपकी मेन कंपनी है, पेरेंट कंपनी है ये आपकी. यस, ठीक है, मेन कंपनी हो गई सभी लिमिटेड. A public company and Sabhi Limited is a public company because limited is given over here and it's a public company और ये incorporated है, ठीक है, Companies Act के अंदर. Now Abhi Private Limited want to avail exemption as provided to private company. अब now this subsidiary company wants to avail the exemptions with respect to whatever the restrictions that we have given. He want to avail all those, what are the benefit is given to the private company or exemption is provided. So he just want to avail all those benefits of a private company.
So whether it will be covered as a private company or a public company. So if you see the main provisions, you will not get the answer. For this, you have to see the proviso, which is proviso means an exception to the main section.
तो आप देख सकते हो हिसाब से, यू कैन ड्रॉ द कंक्लूजन ऑफ द आंसर। सिंस यहाँ पे हमारा प्रोविजो क्या कह रहा है कि जो मेन कंपनी है वो पब्लिक कंपनी है, ठीक है। अगर उसकी कोई सब्सिडरी, इवन इफ इट इज अ प्राइवेट कंपनी, दैट सब्सिडरी कंपनी विल बी डीम्ड टू बी अ पब्लिक कंपनी। सो यहाँ पर यू कैन इजिली मेक इट आउट दैट जो अभी प्राइवेट लिमिटेड है सब्सिडरी कंपनी विच इज अ प्राइवेट कंपनी, तो यू कैन सी हियर will be deemed to be a public company. Why? Because of being a subsidiary to the public company.
So will this Abhi Limited lose the status of being a private company?
बताओ भाई, चलो चलो students, kindly let us know whether now this exemption which is there for the private company, can it be availed by Abhi Private Limited?
Yes, you can write about the paid up share capital in the public company, and nothing is given as of now. Yes, their definitions can be asked directly also.
Yes.
Subsidiary.
Yeah. So it's a subsidiary. That is right. With subsidiary company is a public company. Now it is very clear that it cannot avail the restrictions whatever imposed under
now
the
it
private
became a
company.
Public company.
Yes.
Correct.
Now the Abhi Private Limited deemed as public company.
The correct word to use here is, like students are writing, it will be a public company. No, it will be deemed to be a public company. For its own purposes, it will be Abhi Private Limited only. It will not lose its status of private limited company. It will be deemed to be a public company. Okay. Always use the word deemed. In law papers, it is very important to take note of few of the terms. Like if you write Abhi Private Limited will become a public company, so that will be a wrong way to write it. You have to say that Abhi Private Limited will be deemed to be a public company, and hence it may not be allowed, it will not be allowed the exemptions and all these things of a private company. But the word to use is deemed. Yes, correct. No, Abhi Limited is a deemed public company. Correct. Very good. So next is your associate company.
Okay.
Section 2, clause 6.
Okay. Here has specified the main aspect, you can say, what is requirement for any company to be termed as associate company. So here the associate company is to be considered in relation to another company. That means there will be two companies in order to draw the relation, you can say. So it is considered in relation to another company. This is the one aspect you can say. Second aspect is there in which that other company, okay, has a significant influence. Okay, because in relation to which company we are talking about, that other company shall be holding a significant influence in this first company. Okay, now saying that that company shall not be a subsidiary company in which you are holding a shares, or you can say significant influence, that company shall not be a subsidiary company.
And had that been a subsidiary company, there would not have been, there was no need to have a distinction between a subsidiary company and an associate company.
And then next is, however, such company can be a joint venture company. It includes, it can be in such a nature. Okay. So you could be seeing a simple thing. There are two nature of the company. So suppose I'm talking about the X company. Okay. And it's said to be considered in relation to another company. Suppose this is another company. Okay. Now it says that other company, yani ki this other company shall be having a significant influence in this X company. So here this company will be termed as associate company. But in order to draw what is a significant influence, you need to go into the explanation given over there. And this associate company shall not be subsidiary company. Remember this. So you need also to know what is a subsidiary company. That means significant influence. Requirement of being a subsidiary company, that needs to be known. And however, these relation could exist and it can be included as a joint venture.
So now the question arises that we have marked that significant influence, that what is the meaning of significant influence. So this you can understand this by way of this diagram also. This is company A, which is an associate company, like the student was saying that please explain it again. And there is company B. If this company B has significant influence in company A and it is not a subsidiary, and then we have given another limit to it which says that it includes a joint venture. So understand few things here. The main things come, we are using the word significant influence. Okay. So significant influence means control of at least 20% of total voting power. Total voting power has been defined later on and we will discuss that also. Or control of or participation in business. See, earlier also we read somewhere in whose
Promoter's definition.
yes, promoter's definition, on whose directions
Whoever control over the affairs of
the company or accustomed to act according to the directions. Okay, so these are like whenever there has to be control, either it will be by way of shareholding or controlling the composition of the board of directors. Okay, so here we are saying just 20% of total voting power. Had it been 50%, 51%, तो वो subsidiary के केस में चला जाएगा. It will altogether change.
मतलब आप यूं समझ लो रेंज है आपकी 20 से लेके आप लेस मतलब ये है 49.99 समझ लो. मतलब लेस देन 50% बेसिकली. तो बस अगर ये रेंज ऑफ परसेंटेज है तो देन इट विल बी कंसिडर्ड सिग्निफिकेंट इन्फ्लुएंस एंड देयर इट विल
in fact it should be less than 50 up to 50% because 50.1 will be holding subsidiary relation. So let's change
make it 50.
It is, sir. Blah.
So this will be associate company. Agar if the significant influences of at least this in between this range.
So joint venture is a simple definition, means a joint arrangement whereby the parties that have joint control of the arrangement have rights to the net assets of the arrangement.
In simple word, if two or more parties come together to do any business, you can say, and whereby they are making an arrangement as regarding the investments or some kind of working arrangements in the form of certain arrangements, in form of some agreement, then this should be said to be a joint venture.
Is it clear, students? Because many a times question come on the concept of public company. Thank you. And on the concept of private company also comes because of the exceptions that are given. And so take a note of it. Then public company because of the proviso, and on the associate company also because of they will give you a situation and ask you to see that whether they have a significant influence or
तीनों ही definitions बहुत important है.
Quick way to
So please don't skip in any of the form.
Fiduciary capacity, where is it written? Fiduciary capacity as such means a position of trust, where the relationship of trust is there. So that is known as fiduciary capacity. I don't know from where you are asking, but that is the meaning.
It is there below. Somewhere in the subsidiary company's definition is there. Fiduciary capacity.
Ma'am, you said before getting assent from president. No, it is to be notified at official gazette.
No. Only after getting the assent.
President's assent.
Yes, this is the prior step before just giving it in the official gazette.
Yeah, so it cannot be there. So moving on to the next definition. Is 242 clause 46. That is your holding company. So now move on to the next important definitions, which is your holding company, and then simultaneously we will also be dealing with the subsidiary company. So holding company, okay. just remember one thing. If you see private and public companies, private company ke case, they have kept private company at the base and they are saying that by articles they restrict so thing. When they were telling us, they means the act was telling us about the public company, they said which is not a private company. Okay. Then when we started reading the definition of joint venture, because two companies were again involved in private and public company, there were no two public companies. There were no two public companies, but in case of associate company, because you need to have control, that means two companies are needed.
Of course, it will be associated to someone, na? It cannot be
Yes.
alone. So you require two companies.
It will be in relation to another company.
Yes.
So these are key terms that you will be writing in your examinations also, and that will help you to remember also. Now, similarly, when we'll be dealing with holding and subsidiary company, because once again the terms control, power, all those will come. So again, it will be in relation to some other company. Okay. So in section 2, clause 46, holding company, in relation to one or more. So you can be a holding of not only one, but you can be a holding company of more than one company.
Yes.
In relation to one or more other companies, a company of which such companies are subsidiary companies. So now again इन्होंने बोल दिया कि subsidiary company की जो company होगी वो
पहले
holding होगी.
सब्सिडरी कंपनी पढ़ा देना चाहिए, फिर तो ये लगता है.
हाँ.
First you should need to know about the subsidiary. Similarly, what we read first, private, though arrangement is later on in the
Yes.
act, but why we have given it preference? In order to make you easily differentiate between the public and the private company. Similar here, I hope, Shraddha, we should first teach them subsidiary in
company.
order to understand this holding company.
So I'm just telling you that the way they have defined, जो ये नहीं है ये वो है. Okay, so let's move on to section 2, clause 87. So let's speak up. Section 2, clause 87. Oh God. After getting president assent, then only notified at the official gazette. Yes, and that can be done simultaneously also. Official gazette के बाद फटाफट single day में ही official gazette में भी हो जाता है.
कंपनीज एक्ट के इसमें थोड़ा टाइम लगा,
वन
दिन एक दिन का गैप था.
जरूरी नहीं है. जर्नली जिस दिन प्रेसिडेंट का एक्सेंट मिलता है उसी दिन हम हाथों हाथ ऑफिशियल गैजेट में चला जाता है. ओके, सो सब्सिडरी. ओके, जस्ट लुक एट दिस डायग्राम. व्हाट डज दिस से? Relation to any other company. Again, any other company, because we have to read it in terms of any other company. Means
limited to this what is given over here.
Means a company in which the holding company controls the composition of the board or exercises control of more than one half of the total voting power. One half, 50% plus. So it cannot be 50%, more than 50%. So in this definition, it is very important. Just first learn two terms. One is more than one half. It's not one half, it's more than one half. I'm emphasizing on it again and again. It's 50.1.
More than one half means 51%.
Yeah, 50.1 also.
Huh. Yes,
so
it could be, but
more than 50. It cannot be 50. Okay. 50.1, 51. Generally, they will not give you 50.1. They will give you 51.
Because in decimal, there will be a round figure.
Yes.
Generally. So
yes.
that is
shareholding को उसमें करना मुश्किल हो जाएगा. So then it has to be like there are two limbs to this. So this is a company, and in relation to this, there is a holding company. A company in which the holding company can do two things. Either control the composition of board, or the word here is or, exercise or controls more than, very important, more than 50%, more than 50% of total voting power.
Or here the word control of BOD may include either appointment of the directors, because board of directors comprising of the directors, so either their appointment may be controlled, or any kind of, you can say some major business decisions. Is there something to regulate or manage the company? If there is a proper control in the business decisions, that will also be considered as an control of the board of directors. And compositions basically with respect to appointment or the exercise of any rights.
So let's understand this with the help of an example illustrating. Okay.
This is what same this diagram has been explained above. But yes, here is the holding company. Okay, if that holding company is having the control over the composition of board in subsidiary company, or even control or exercise of more than half of the total voting power, okay, either singly you can say, or either with one or more other subsidiaries. That means it can be either with the, there can be more than one subsidiary companies also.
Yes.
So it can be, if this is the possibility of control or exercise within any company, then you can say this company in which that holding is there, that company is the subsidiary company to the this holding company. So this line, you can see one more thing is there in an example. Suppose this is the holding company, this is the subsidiary, and this is again subsidiary too. So you can say that this holding company can either have holding in both the companies, okay? And suppose if this lower company S2 is, suppose S1 is controlling the holding in S2, then automatically, since S1 is the subsidiary to H, so this company will also automatically will become the subsidiary to the holding company. That means there is a common holding company to S1 and S2. Either individually the company is having shareholding, or either if one of the subsidiary companies having holding in the another subsidiary, and that subsidiary company which is having holding is the subsidiary to the another holding company. So automatically both the company will become the subsidiary
of
to the
parent
holding company. Yes. So that is why subsidiaries is used, because it can be more than one company.
So what are the restrictions on subsidiary? Provided that such class or class of holding companies shall not have layers beyond the prescribed number.
Now prescribed is rules, and in the rules it's given 2 layers. So as we have given above in the example, we have considered 2 layers, and suppose there is one more S3. So this company will not be considered as a subsidiary because restrictions has been marked up till 2 layers of the company.
So for this clause, they are defining that what is the meaning of control is of another subsidiary that we have just discussed. Then the composition of board of directors shall deem to be controlled by another company if they can have the power to appoint
or remove.
Ma'am, have we started second chapter also?
No, not as of, but yes, section 19 is there in the second chapter. There, this particular definition will be, you can say, will be referred over there. Yes, and this is very important thing I'm telling you. This concept is very important. So understand it properly, because this will help you in there when you will read section 19.
No, this is not second chapter. This is first chapter only. So the expression company includes a body.
Yes, already we have told you this part.
And the layers we have discussed with you. Then the thing that you were saying, fiduciary capacity. So if, like we were saying, that you have to understand the total voting power concept. So if the shares are held in a fiduciary capacity, which is as a trustee, then
it shall not be counted for determining the holding subsidiary relationship. This is an exception. So you should always read any provision in entirety to understand the section as a whole, because any portion of the provision can be tested in order to know whether you have understood the provision in complete sense. So this is what an example. You even know you should know about the requirements. What are the requirements for being this relationship of holding a subsidiary company, and what are the additional explanations which has been defined at particular requirements in order to be a subsidiary company. And then it has said about the exception. If that exception is there, again it will be out of the purview of that subsidiary company. So you need to have this understanding, right?
So this is the last example. We will not be taking much further. So I think all of you must be tired. This is your first technical session. So it is a well-known, Infosys Limited is a well-known IT service company. It owns 100% shares of another company called Infosys.
This is a BPO company.
Okay, BPM Limited, Infosys BPM Limited. It is a separate legal entity providing business process management services. But since Infosys Limited owns all its shares, Infosys BPM is a subsidiary of.
क्योंकि इसकी आप शेयर होल्डिंग देख रहे हैं, मोर देन 50% के हमारे यहाँ तो पूरा का पूरा ही उसने कर रखा है, फुल्ली ओन्ड है. दो इट इज यू कैन सी, इसलिए ये जो पब्लिक लिमिटेड है, इट्स अ लिमिटेड कंपनी, और आप देख रहे हो कैसे वो सब्सिडरी कंपनी को उसने होल्ड कर रखा है, एंड इट बिकम्स अ रिलेशनशिप, इट इज बीइंग क्रिएटेड ऑफ होल्डिंग एंड
बिफोर गोइंग ऑन टू कंट्रोल, students are like,
any queries is there, so we can take up and wind up
and
the
we
session.
will take up this holding subsidiary concept again in the next class.
Yes,
But request you all to kindly read and then come. So you will be in a better position to understand. Any queries or all clear? Don't be afraid that we have to learn all the different procedures to come stepwise. It will be like you will understand everything.
आप एक काम कर सकते हैं, you read these notes, and these notes, this will definitely help you, because whatever we have explained you, that
and apart from notes, I will say just read from the study material.
Even study material you can go through. Study
Because
material
it's
well, because
very good. Thank you. So it's like कि अगर आप अपना study material पढ़ेंगे ना, if you read from the study material, it will be much better.
क्योंकि study material जो होता है वो आपको in depth insight throw करता है what exact the whole law is, because we are taking only crux. Crux is just for understanding, but when you have to write any answer in the examination, you need to write the complete answer, the complete provisions. So requested to go to the study material.
Just read whatever sections we have done. I'm not saying that read all the sections. At least read the sections that were done today. Okay. All clear, all clear. Thank you. So we will see you again on Monday.
Yes.
And with this, we have come to the end of this class.
But only one last line before ending up, because already too much. It's 8:50. है ना? तो बस मैं यही कहूंगी, जो आपकी पढ़ाई होती है, इट्स लाइक प्लांट. जैसे आप प्लांट की देखभाल करते, यू गिव द वाटर एंड यू जस्ट गिव द फर्टिलाइजेशन एंड प्रॉपर दैट सनलाइट. Similarly, when you do practice and read and study, so definitely it grows, that plants grows, and definitely it won't give the result instant. There will be a flower or a fruit. Yes, it will take a time. So similarly, padhai may be jo result it won't be reflected at once, but if you read and you practice and you just be continuous in your studies, so you will also be, that plant will grow, and one day when it will become a tree, it will give you a fruit and the good results. So just have a hope and dedication and consistency, and be with the positive mindset. Definitely you are going to get the success, and you will be very happy with your approach that you will be following. Yes, I am doing up and I am able to do it. This is the main thing that is lying within your heart, and you'll be very happy with that. So we would like to close the session. Is there any query?
No.
Okay, so dear students, have a and thank you for being with us. And it was really a great session, being so interactive, and you all students taken very well interest in the sessions. And with this, we would like to close and end the sessions. Have a good day and good night.
Good night.